they didn't meet the criteria. The district court noted that and found that as a matter of law. They did not meet the criteria because they didn't believe that he was a danger to himself or others based on the fact that it was not the result of a mental health impairment. So we're talking about somebody who is never a threat to anybody, who said please 63 times, who is essentially begging for his life. And when you look at the video, and I noted this after viewing the video maybe 100 times, as they're trying to transport Mr. Scott and they're walking with him, you see one officer pivot. Now the body cam does not show his lower body, but you can see the pivot, the change in his body weight. And then immediately Mr. Scott starts to fall down. I believe that that's at least a factual question. Did he use his foot, do a leg sweep or a foot sweep, to try to get Mr. Scott to fall to the ground? Because he did go right to the ground after that movement. So you've got the excessive force in the weight on the 1 minute 42 seconds on a prone person, and you've got the excessive force in the takedown. And the court noted in his order that that is at least a plausible factual question to be determined by a jury. So for the appellants to come in and ask to relitigate the entire case based on a very well-reasoned, thought-out order determining what the facts are in this case and what the law is, I believe is a misuse of the interlocutory appeal process. There's a very narrow, limited scope to interlocutory appeal, and I believe that the motion to dismiss should have prevailed. This is not a case suitable to...
Counsel, I'm going to turn your attention for a moment to the 14th Amendment claim.
Surely.
And I'd like to ask you, what is the most on-point case clearly establishing Rochelle Scott's 14th Amendment rights were violated?
Well, I know that the 9th and I believe the 10th Circuit are the only circuits that recognize that standing, but that's not disputed. That is the law, and I believe Gonzalez versus Anaheim and some other cases determined that, and I don't recall specifically what's the most on-point case for the 14th Amendment standing claim, but that is the law. And in fact, in the appellant's brief, they argued that, well, that's the law in the 9th and 10th Circuit. However, in other circuits...
I'm asking you about what case in particular you have that goes to the clearly established prong. So what case can you point to that says this is the law that tells us that a 14th Amendment claim is clearly established? That the constitutional violation is clearly established?
If you give me one moment,
Sure.
I didn't anticipate that exact question. So let me search. I'm almost there. Well, we argued Greer rather, which is the on the time to deliberate on the issue of the 14th Amendment, and we argued Garlick, time to deliberate. But as far as the standing issue, I didn't think it was really disputed that there is standing allowed in the 9th Circuit for an adult child to sue on behalf of her deceased father. I know some cases, the damages may be limited. There's no economic damages in that case for the 14th Amendment claim. She wasn't dependent upon Mr. Scott for support, but there's no I don't have.
I guess the question is not standing. The question is under the 14th Amendment. Is there a case that discusses using unwarranted force when restraining a suspect under the 14th Amendment? Is it clearly established that police officers violate a plaintiff's 14th Amendment right by using unwarranted force when restraining a suspect under the 14th Amendment? Clearly under the 4th Amendment.
Yeah, if you can show either a deliberate indifference or a purpose to harm. The purpose to harm is only when there is not time to deliberate, but there is a body of law on the question of whether or not there's deliberate indifference, and the purpose to harm standard only comes in when the officer does not have time to deliberate. So in this case, the officers had time to consider their actions and what they were doing and to assess what's going on, to call for more help, to call for the sergeant again to see what's going on. I mean, it's a higher standard, a higher burden for the plaintiffs in these cases to prove the 14th Amendment claim, but it's not really a disputed claim in the Ninth Circuit. I mean, parents and children have standing to sue on behalf of their adult either parents or children, and other circuits may not have that same standing, but Ninth and 10th do.
Mr. Goldstein, you're out of time. Maybe you want to make a closing statement.
Certainly, Your Honor. Thank you. I just thought that the limited scope of the review, the fact that the trial district court determined that there was no probable cause based on a very specific reading of the statute, which at the time was different than it is now, but required that all those elements of, a danger to himself or others, which he was not, he didn't, and the officers testified as to all of that. They were never in danger. He did not commit any crime at all. He was in his apartment.
Thank you, Mr. Goldstein.
Thank you, Your Honor. Your Honor, thank you very much.
Thank you for the extra time. I'll be brief. And I think what we just learned is that there are no cases directly on point clearly establishing this law. When you asked Mr. Goldstein about whether there's any case law saying that Drummond applies to pre-handcuffing force, he said yes, but didn't give you a case because there's not one. If you go to page 45 and 46 of my brief, I cite 8 cases. None of them were published Ninth Circuit decisions, but they're cases interpreting Drummond. Every one of them says it applies to post-handcuffing prolonged use of force. In fact, in Drummond's conclusion, in its own opinion, it says this applies to prolonged use of body weight force. He just said yes, but couldn't give you one case that applied to pre-handcuffing force. So the appeal is justified. This is a proper interlocutory appeal because even the district court, which Mr. Goldstein cited to as well, reasoned and clear, the 2 cases that it gave you was Young versus County of Los Angeles and Bryan versus McPherson. Young versus County of Los Angeles is a case where an officer beat a guy eating broccoli with a baton. Hardly the facts we have in this case. The case of Bryan McPherson was a taser case where a gentleman was standing in the street upset and an officer tased him in dart mode when he was not a threat. Not even the district court could find one case that said that pre-handcuffing use of body weight is unconstitutional. And so under the clearly established prong, even accepting all the plaintiff's facts as true, there would still have to be qualified immunity on those grounds because there is no case on point that says using body weight and to restrain someone. And the 2 best cases is Drummond is basically on point with this case. Drummond is right in point with the severity of the crime, what the suspect was doing, what the officers did. The difference is in Drummond, they stayed on him for 20 minutes. 2 officers, full body weight, sat on him for 20 minutes. Here the officers were off within 8 seconds. And so it's easily distinguishable and there should be qualified immunity granted on that. I agree with Your Honors on the 14th Amendment. The issue is not standing. I understand that you 3 cannot create a new rule that there's not standing. I just put that in there to preserve it in case this were to go up on bong to get that changed. But there is no evidence in this case that these officers were acting for any reason other than a legitimate law enforcement objective, which is the 14th Amendment standard. that they have to have a purpose to harm, unrelated to any legitimate law enforcement standard. There's just no evidence of that in this case, and the 14th Amendment claim should have been dismissed as well. Unless you have any questions, I will stop.
No, thank you very much.
Thank you, Your Honors.
This case is now submitted.